I've been told we will begin in about 2 minutes.
I don't know who you are, but thank you. Wherever they told me to stand. It's all good.
Okay.
We need it in here first.
Good afternoon, everyone. Thank you all for joining us. My name is Alfonso David. I am a civil rights attorney, and I'm also the president and the CEO of the Global Black Economic Forum. I have spent more than 25 years litigating economic justice and social justice cases all over the country. And today I'm proud to serve as one of the lead attorneys representing several plaintiffs in the lawsuit that we are announcing today. This afternoon, we filed a landmark lawsuit here in Travis County, Texas, against several state officials for violating the law and disenfranchising more than 15,000 minority-owned and women-owned businesses throughout the state of Texas. In the early 1990s, the Texas state legislature passed a bill that was signed into law by the governor to address widespread and documented disparities in state contracting. The Texas Government Code, Chapter 2161, commonly referred to as the HUP program for historically underutilized businesses. The record shows that businesses owned by women and businesses owned by Black, Hispanic, Asian Pacific, Native American, and service-disabled veterans were being systematically excluded from the contracting process. Even though they were qualified to perform the work, they were being denied opportunities to even compete for contracts. That law, which was passed by the Texas legislature, is still on the books. It is still active and it is still necessary. Black, Hispanic, Asian Pacific, Native American, and women-owned businesses continue to be grossly underutilized in the state contracting process. Nevertheless, on December 2nd, Acting Texas State Controller Kelly Hancock issued an emergency regulation to remove all contractors who are people of color and women from the HUP program. Instead, his regulation sought to limit only to service-disabled veteran-owned businesses. And he, in fact, renamed the program the Vet HUP program. A month later, on December 6th, the controller followed through and decertified more than 15,000 HUP-certified businesses owned by people of color and women. Several state agencies followed through and implemented the controller's regulations by removing all of those businesses from their programs. These actions are politically motivated and unlawful. The controller does not have the legal authority to ignore the laws or rewrite the laws passed by the Texas state legislature. By issuing an emergency regulation contrary to law, he has violated several fundamental aspects of Texas law, which we will talk about in a few minutes. The agencies who implemented the regulation also ran afoul of the law. So today we filed a lawsuit against 4 entities: Acting Texas State Controller Kelly Hancock, Mark Williams, the Executive Director of the Texas Department of Transportation, Stephanie Muth, the Executive Director of the Texas Health and Human Services Commission, and Will McCarroll, the Executive Director of the Texas Facilities Commission. The plaintiffs in this lawsuit are standing behind me. They are 4 minority-owned and women-owned businesses and a statewide trade association. So what is at stake? These businesses, along with many others, are at risk of losing business opportunities and suffering significant financial harm as a result of the actions of the controller and the state agencies that we're suing. In fiscal year 2024, more than $4 billion, with a B, in state contracts went to state-certified businesses. The 3 agencies named in the lawsuit awarded more than $1.6 billion in hub contracts last year alone. These opportunities are now effectively unavailable to more than 15,000 businesses that were decertified. Many of these businesses structured their long-term growth strategies around the hub certification. Some contracts have been canceled. Others were halted mid-negotiation. The hub program has existed for more than 35 years and was created by the Texas State Legislature to expand opportunities for people of color and women. The controller and the state agencies, again, do not have the legal authority to change the law. And this case centers around a basic principle of democratic governance, reaffirming that executive branch officials cannot override the law. And that principle is not limited to this statute. If we allow this brazen action to stand, any member of the executive branch could effectively ignore the law or try to rewrite it. The citizens of Texas did not elect or authorize the appointment of executive officials to enact laws. They elected the legislature to do that. This lawsuit, on behalf of the courageous plaintiffs, seeks to make sure that their rights and their principles outlined in the Texas Constitution are respected. And there are many people involved in this fight, some of who you will hear from today. First, you will hear from Adam Schuman, who is a partner at the law firm Petrillo, Klein, and Boxer, and is serving as one of the lead attorneys on this case. He will outline the key claims in our case. Second, you will hear from our clients, the courageous plaintiffs, who are fighting to make sure that the rights of more than 15,000 businesses in this state are protected. You will hear from the plaintiffs in the following order: Ruben Mercado Jr., Tyrone Dixon, Cortina Williams, Ray Gutierrez, and Wendell Stemley. Third, you will hear from the members of the state legislature who are supporting this case and representing the interests of many colleagues in the state legislature. Speaking today will be State Senator Royce West, State Senator Carol Alvarado, and State Representative Barbara Gervin Hawkins. Now, before we go to Mr. Schuman, I want to acknowledge our local counsel in the room, Chad Dunn, who was working on this matter with us. I also want to acknowledge organizations, Freedom Economy and the American Pride Rises, for supporting this litigation. And now to Adam Schuman.
Thank you, Alfonso. Good afternoon, everyone. As you heard, my name is Adam Schuman. I'm a partner in the law firm Petrillo, Klein, and Boxer, and serve as co-lead counsel in this case. Earlier in my career, I served in government, first as a federal criminal prosecutor, and also as special counsel for public integrity in state government. This case is critically important to upholding the fundamental principles regarding how state government is supposed to function and whether the executive branch will be required to respect and to comply with the laws of the land, or instead will be allowed to pick and choose the winners and the losers based on their political views. As you heard, we filed a lawsuit today against several state officials for violating a variety of well-settled legal principles. I'm going to summarize our claims for you so that you understand the basis of our lawsuit. We have filed 16 counts against the defendants. Those counts fall into 3 core categories. First, acting controller Hancock exceeded his authority in direct violation of the statute setting up the HUB program, Texas Government Code Chapter 2161. That was duly passed by the state legislature and created and defined the HUB program. As Mr. Hancock should know, since he himself served previously as a member of the legislature for years, the state controller simply lacks any power to unilaterally restructure and dismantle the HUB program by a so-called emergency regulation. In our petition, we therefore assert that the emergency regulation is void under the Administrative Procedures Act because the acting controller lacked statutory authority and constitutional authority for a so-called emergency regulation. The HUB statute, as passed by the legislature, explicitly defines what HUB means. H is for historically, U is for underutilized, B is for businesses. These are Texas small businesses that by statute are majority owned by Black Americans, Hispanic Americans, women, Asian Pacific Americans, Native Americans, and veterans who have suffered at least a 20% service-connected disability. Yet, in one fell swoop, the acting controller attempted to issue an emergency regulation to remove minority and women-owned businesses from this statutory HUB definition created by the state legislature. The emergency regulation, therefore, is illegal and invalid because an administrative rule simply cannot contradict the plain text of a statute. It's that simple. Because the Texas Constitution creates distinct legislative and executive branches of government, the emergency regulation is also invalid because the acting controller violated the constitutional separation of powers when he overstepped the limits of his executive authority. In the second category of our claims, the emergency regulation was defective because it failed to meet the procedural requirements even when you are issuing an emergency regulation under executive authority. At the outset, it's clear there was no emergency, none that existed that would allow Mr. Hancock to avoid the required rulemaking procedures. The HUB program, as Alfonso said, has existed for 35 years. No one's health or safety was in jeopardy by its continued operation. Indeed, the legislature just last year debated a bill like Mr. Hancock's so-called regulation, and the legislature refused to amend the statute. It's therefore clear that the acting commissioner declared an emergency without any genuine basis, but motivated by political wins, a democratic process that went against his position. Mr. Hancock should have deferred to the outcome in the legislature, even if he didn't like it. In addition, the acting controller tried to avoid basic requirements in the issuance of regulations, which are designed to ensure public transparency and input to any rulemaking. For example, the acting controller failed to comply with the requirements for 30 days advance public notice and a reasonable opportunity for interested parties to comment. Due to these procedural violations, too, the emergency regulation must be annulled. Third, by decertifying thousands of businesses that had lawfully held HUB status for years and decertifying them without notice, without a hearing, without due process, the acting controller deprived them of a state-created property interest in violation of the Texas Constitution. Plaintiffs have a property interest in their HUB certifications. As you'll hear today, the HUB certifications were important for them to compete for state contracts on an even playing field. The acting controller violated plaintiffs' due process rights by wrongly decertifying them and denying them access to the HUB program. The acting controller also violated plaintiffs' equal protection rights, as well as a Texas anti-discrimination statute, by denying them access to the HUB program's benefits due to their races, ethnicities, and sexes. With respect to the state agencies, who are also defendants, all three officials, just like the acting controller, have failed to comply with explicit requirements under the HUB legislation. Our executive branch leaders are violating the law when they act without authorization and contrary to statutes passed by the legislature. For all these reasons, our lawsuit seeks a declaration from the court that the emergency regulation is null and void, and we seek an injunction prohibiting its enforcement and requiring reinstatement of HUB certifications. We look forward to having this case heard in court. We are confident that our claims will prevail. The emergency regulation is a political maneuver by Mr. Hancock. It's legally indefensible, and we will seek to have it overturned as soon as possible. We'll now hear from our plaintiffs. First, Ruben Mercado.
Good afternoon, all. My name is Ruben Mercado Jr., and I'm founder and chairman of Ipsum General Contractors out of Houston, Texas. We're a civil construction company. I'm a proud Hispanic American and veteran of the United States, and I built Ipsum General Contractors over more than a decade. After spending more than 20 years working in the construction industry, I founded Ipsum because I recognized there was a need for more construction companies owned and managed by Hispanic Americans in Houston. Ipsum has provided civil construction services to the communities across Texas. The HUB certification was important to my business and model and growth strategy. In fact, my percentage was 85% of all business the past 2 years were HUB related. Last Monday, I lost a $2 million multi-year contract with MD Anderson. And while they didn't say it was connected to the controller's decision, I find it strangely coincidental. In addition, I had a $1 million bid that was killed before I could even finish submitting it. In the absence of the HUB program, small businesses like mine are kept out of the competitive bidding process. I have experienced race-based bias firsthand in the face of Ipsum. I have been ignored by clients who assume I am not Ipsum's owner because I'm Hispanic. Clients have challenged my authority and knowledge on the job site because I'm Hispanic. The HUB program helped level the playing field. The HUB program didn't hand me anything. It opened the door. We still had to win the contracts on open competition and deliver strong results. That's all any of us are ever asking for, a fair chance to compete. I have 20 employees who rely on the success of my business for their livelihoods. I am here today because what happened to me is to thousands of other businesses across Texas, and someone has to stand up and say enough. Thank you.
Good afternoon. My name is Tyrone Dixon. I'm owner of Impulse Healthcare and Technology out of Sugar Land. My late wife founded Impulse Healthcare in 2005 in support of the University of Texas Health Science Center in Houston, providing clinical resources. After her unexpected passing, I stepped in as the role of president and CEO, and to honor her legacy in 2006, I consolidated my wife's healthcare company and my own technology company, and now we're under the name of Impulse Healthcare and Technology. Impulse is a trusted distributor of technical hardware and software, medical products and supplies, maintenance and repair and operational products. We are currently supporting the Texas State University system, the top 7, along with state agencies throughout the state of Texas. We're a trusted distributor. We were HUB certified in 2008. The HUB certification positioned us to compete for state contracts. And with years of work, building relationships, and preparing to support the pipeline, without our HUB certification, that would be impossible to provide for these clients that we currently work with. The HUB program, what it does for us, it increases the probability of success for minority-owned small businesses, giving us the opportunity to compete with other billion-dollar companies. I work with some of the largest distributors in the U.S. Keeping us from being considered, to being invited to the table to sit and discuss opportunities. But despite of our proven track record, we're still in business. But there was no warning, and there was no due process in this case. And one morning we were certified, and then because one official decided to rewrite the law of the legislator and had no intent of changing. Healthcare and technology and distribution and our specialization in that area, the state needs companies like Impulse Healthcare and Technology to serve the people and the students and the young folks of the state of Texas.
Good afternoon, everyone. My name is Cortina Williams, and I am the proud founder and visionary of Williams Professional Water Restoration Service, LLC, doing business as WPWRS Construction Services and Disaster Restoration. I founded my company in 2014 because I had the desire to help others. For years, we have helped families, businesses, and communities rebuild after experiencing unexpected disasters. We're licensed to build, trusted to restore, and proven to lead. But our journey to success has been difficult. As a Black woman-owned business in a male-dominated industry, construction to be specific, my company has encountered implicit and explicit gender and race-based discrimination. It has often been unfairly excluded from bidding on large construction contracts and overlooked for restoration projects. I've been called the little restoration lady and forced to work twice as hard as white male counterparts at competing companies. Over the last 2 years in Texas, I built my business model around the HUB program. I earned my HUB certification, and I said earned, and met hundreds of potential clients through the HUB-sponsored events. Just before the comptroller's illegal actions, I was deep in negotiation of contracts with Parkland Hospital and Texas A&M University. Real work, real opportunities, ready to go. The comptroller's actions ended those conversations tonight. Not because my work wasn't good enough, not because I wasn't qualified, because one official decided without any legal authority to eliminate the program that gave me a path to compete. As a Black woman business owner, I know how hard you have to work just to get to the starting line. The HUB program provided that equal opportunity which the comptroller took away from us. I am not going to accept that. The right to compete for these opportunities is protected by law, and I intend to see that law upheld, and I will be the voice for those that don't have the voice.
Well, good afternoon, all. Thank you all very much for coming here. Y'all are what they call extremely important to us. I am a third-generation Texan. I've been here a minute. My name is Ray Gutierrez. I'm with a company called Houston Construction Services. I have been a small business owner for nearly my entire life. I have worked hard for the following in the footsteps of my late father, and in my effort to build a successful business to achieve my dream of being an entrepreneur. But I remember when opportunities were not acceptable to me, I could not secure meetings with prospective clients because of how they reacted to my last name. The HUB program changed that and opened doors so that I would be fairly considered for state contracts. An entirely new wave of opportunities opened up for my business to be considered on the merits, on the fair playing field, and my business has competed successfully without regarding my ethnicity. I was incredibly upset when the controller recently decertified my company from HUB because of my ethnicity. The controller effectively closed the doors on my business to work on contracts that I've actively pursued, including through business relationships I have spent many years. The controller has no right to take away from me. My father's entrepreneurial spirit taught me how important it is to take control of my own destiny. That is what led me to open my own business. Many years ago, when I was challenging the illegal action, we are here today because the law is on our side and we expect the courts to recognize that. Again, thank y'all for being here.
Good afternoon. I'm Wendell Stimley, President of the National Association of Minority Contractors. Dissertation, but I'm here to tell you that if the Houston Hub program for the chapter in Houston and throughout Texas, we came to support. If a battle is to be fought, we will show up. I got a call from this gentleman, Mr. Roy West, about the issue going on here in Texas. I spoke with even the local council, Mr. Chad Dunn, and Alfonso was able to put this coalition together. So I won't belabor you, but I'm saying if there is an issue, if there is a concern, as the oldest minority trade association in the United States, we will show up with the right team to fight this. Thank you.
I want to say good afternoon to each and every one of you. You know, the Texas Constitution is not a suggestion. It is the definitive roadmap for how our government must function. Must function. Today we stand here because that roadmap has been ignored by an unelected official who believes his personal policy preferences and his consultants carry more weight than the statutes of the state of Texas. That's unfortunate. I pause. I've been on Kelly Hancock for the past 15, 20 years, and this is not personal, Kelly. The fact of the matter is that anytime you've called me, I've called you back. When you first came out with this particular initiative, I called you and asked to sit down and talk about what was behind it. To this day, we haven't met to talk about this issue. The Historically Underutilized Business Program was created not by an elected official, but by the Texas legislature. It is a product of the democratic process passed by the elected representatives of the state and signed into law by the governor of the state of Texas, who was then George Bush. I want you to look at this program, and you'll see it's a good faith program to make certain people that are defined in the particular statute have an opportunity to compete. It's not a quota program. George Bush would have never signed a quota program. Some people want to make it a quota program. It's not that. You know, in 2025, as Session has said a few minutes ago, there had been a robust discussion on these issues, Barbara, in the House of Representatives. As Boris and Carol and Jose and I sit back and watched over in the Senate to make certain that we did whatever we needed to do. We considered House Bill 167, which proposed exactly what the acting comptroller and others now attempt to do via emergency rule. You've heard the lawyers as it relates to what we think about that, and we're prepared to move forward with that. I think about David and Goliath. This lawsuit is against Goliath, the state of Texas, okay? Using our tax dollars in order to fight against us. But be assured, we will pick up the stones that are necessary in order to fight this battle, and we will, in fact, prevail. You see, when the legislature says that is the end of the matter, as it relates to House Bill 167, that was the end of the matter. You can't then turn around and use the executive branch of government to do what the legislature by the Constitution is mandated to do. You know, we're not just talking about a pilot program or a temporary fix. For 35 years, the HUB program has been the law of the land. The legislation was born from my former mentor, about my colleagues like Boris Miles, Jose Menendez, and Carol Alvarado, we've attempted to get what's called a disparity study to update to see whether or not there has in fact been good faith. But every time we've tried to get monies to conduct a disparity study, the answer has always been no. No. Well, we've had to take this unusual step because we now understand and appreciate that the only way that we will get the relief that's necessary is by utilizing the other branch of government, the judicial branch of government. And if the judicial branch of government does what it's supposed to do, being a lawyer for the past 40-some years, I can read statutes. And I know that those persons that serve on our Texas Supreme Court, federal courts, know exactly what the statute says. And hopefully they will hold the executive branch of government accountable. We will not stand by while the constitutional boundaries that protect our democracy are erased. That's what's happening. We are here to restore the law and protect the opportunities that Texans have had over the past 35 years. And so again, I'm asking those that can help us gather the stones in order to fight Goliath, to make sure you help us gather those stones to fight, because we're here to fight.
Thank you, Senator West, and you have been steadfast on this issue since day one, so we appreciate that. I also want to acknowledge other senators that are joined, Senator Jose Menendez, the chair of the Senate Hispanic Caucus, my brother Senator Miles from Houston, and Senator Sarah Eckhart. I know she has an interest in this issue as well. Wink, wink. Okay. You know, this issue has flown under the radar, but today that changes. Today we are elevating the conversation. Today we are putting our words into action. And if you listen to the business representatives that came to tell their story, they didn't talk about political rhetoric. I don't know what primaries they vote in. That's not the point here. They are talking about real life circumstances that have occurred that are affecting their business. Texas prides itself on being a business-friendly state. Well, this isn't so friendly. What you may hear from the proponents of this is probably political rhetoric. But today we had people talk about specific contracts, specific situations that they have been put in. For more than 35 years, the HUB program has been a cornerstone of Texas's effort to ensure fair access in state contracting. It was created because minority and women-owned businesses were being systematically excluded, not because they lacked the talent or the capacity, but because the doors were simply not open. The HUB program gave them a pathway to compete. We're not talking about handouts, we're talking about hands up. And it worked. Minority and women-owned businesses are engines of economic growth across the state, and the HUB program helped to fuel that growth. Thousands of companies hired more employees and created jobs in their communities because they had a fair opportunity to bid. In fiscal year 2024 alone, more than $4 billion in state contracts went to HUB certified businesses. If that's not fueling our economy and creating jobs, I don't know what is. So you can't talk about being pro-business and act another way. That progress was abruptly, without any notice, halted when more than 15,000 businesses, think about each of those businesses employing many people. This has a trickle-down effect that I don't think this state is even close to seeing yet. They lost their certifications overnight with no warning, no due process, and no illegal authority supporting that action. This was not a minor policy adjustment. Oh no, it was It was the erasure of more than 3.5 decades of legislative work designed to correct a documented injustice. The economic consequences of the controller's actions, our former colleague, are already being felt. Canceled contracts, stalled bids, and businesses that may not survive. These are real families. Here they are standing before you, and real workers whose livelihoods are in jeopardy. The businesses standing behind me. And this lawsuit, they have done everything right. They built their companies, earned their certifications, and competed fairly. I can't thank the lawyers enough who have put time and their efforts into this, but especially want to thank the plaintiffs, because we know they are putting even more on the line and making a personal sacrifice. Thank you.
Good afternoon. I'm State Representative Barbara Gervin Hawkins, and I serve as the chair of the Texas Legislative Black Caucus. Now, I'm standing here today with more than just legal documents and policy arguments. I'm standing here with builders, small business owners, and people who create jobs for others. I'm standing here with men and women who took the risk, did the work, had the vision, put in the time, and built their companies from the ground up. These entrepreneurs did everything the right way. But they woke up one day to find out that the foundation has been pulled from under them, not by market forces, but by an official who acted without the legal authority, and in most cases, the moral authority to hurt families and businesses that did everything right. Now, let's be clear. Texans, this is just the beginning. This is just the beginning, so we need to get ready for what's ahead of us. Black-owned businesses were disproportionately impacted by the comptroller's actions, and we must stop that action. When we talk about certifications, we are talking about livelihoods. We are talking about people who earned their way, who did the right thing, who prepared. This ain't a DEI issue. This is an issue related to giving folks a fair chance and an opportunity. We're talking about companies like Impulse Healthcare and Williams Professional Water Restoration. These aren't just names on a spreadsheet. They represent the exact excellence and resilience that the HUB program seeks, and it's been designed to serve and protect. By stripping these certifications, the comptroller don't just change the status, he literally locked the door to opportunity and threw away the key. That's wrong. Make no mistakes, make no mistakes. This is not just an economic issue, this is a civil rights issue, stripping thousands of Black business owners of their hard-earned status without due process, proper notice, and guess what? Transition time. We're talking about trying to treat people fairly that's trying to do business in the great state of Texas. Most importantly, without legal authority. Without legal authority, we're moving in that direction. Texans, let's not have it. Let's not stand by. Let's not stand by and let this injustice stand. In the state of Texas, no official is above the law, and no business should be targeted by executive overreach. Texans, we must fight this. Now I'll tell you, the Texas Legislative Black Caucus has fought for decades to gain an inch of the ground that we have today to make sure we have some type of economic equity. We will not be silent while these hard-won gains are erased by a stroke of a pen or someone's ideology or ideas. We're not having it. We are proud to stand with these plaintiffs who've come forward. We stand with our colleagues in the legislature, and we stand firmly with our legal counsel, Alfonso David, and the Global Black Economic Forum. We stand profoundly sound with them to make sure we get this done. We are here to demand one simple thing, that just the law be upheld. We are here to ensure these businesses are made whole and to ensure that liberty and justice for all applies to the black businesses in Texas and those minority businesses that have been impacted by such immoral and illegal actions. Thank you.
Thank you to all of the elected officials who spoke. As we mentioned, Senator Miles is here, Senator Eckert, and Senator Menendez as well, who are supporting our litigation. We will now open it up for questions. If you have any questions for the plaintiffs, or if you have any questions for the legislators, or of course, if you have questions for us, the lawyers.
I have a question for the plaintiffs, especially the ones that lost contracts with A&M, UT, MD Anderson. They gave you no reasoning behind why they removed your bid or ended your talks?
So for me, I got a text last week, Monday night, saying, we're caught up, we don't need your services anymore, thank you. And it was like, that was very coincidental though, this came after this happened with the HUB program.
Can you emphasize you got it what?
It was a two-year, $2 million contract, we were into it for 6 months, and it was terminated last week, Monday,
By text?
by text, yes, sir.
I was able to speak, yes, please, Ms. Williams.
And as for me, I was ghosted. No response, no return phone calls, no emails, no nothing. And when I tried to reach out to the department, the website wasn't found. It had disappeared.
No response.
No response.
And see, here's another part of the problem. Of course, this is not DEI, this is MONEY. Okay, that's number one. And number two, some of the bureaucrats that have heretofore been involved in the HUB program, they have been thrown into a state of confusion in terms of how to administer this particular program, where heretofore they were administering it obviously with the intent of the statute in mind. But now they have a DEI executive governor's mandate, and then also you have Kelly Hancock, so they're in a state of confusion. And so this lawsuit hopefully will turn around and make certain that we get all of this taken care of.
I was able to speak with Kelly Hancock on December 5th.
I'm glad you were able to speak with him.
Yeah, trying.
Thank you.
He had this quote where he said, "To assume somebody is economically disadvantaged simply based on race or eliminate people from having this preferential treatment in the procurement process or the contract process with the state, that's just discriminatory and doesn't abide with the Constitution." And you'll have a reaction to that.
My reaction is this. You take those arguments to the legislature, okay? You can't make that determination as a comptroller. He has obviously forgotten his role. You made those type of arguments during the legislative process, and they didn't work, okay? Now you take them up to the comptroller's office and make the same arguments and use that as the rationale in order to do away with the statute. Doesn't work.
And let me just respond from a legal perspective as well, because this, of course, is a very seasoned lawyer. The controller can have opinions. The controller cannot rewrite the law. That's our response.
And Senator West, you mentioned, I know Kelly Hancock was the one who made the decision, but you talked about his consultants, quote unquote consultants. Do you think other elected leaders had a hand in this?
Well, after we take his deposition, we'll find out.
And here's something you have to really understand. The executive order from Washington, D.C. is reevaluating everyone, African Americans, Latinos, Asian Americans, Pacific Islanders, Native Americans, to remove the presumption of economic disadvantage status. The state of Texas is overreaching the federal government when they say the quote that you just quoted is invalid, according to the United States of America and even the Trump administration.
Any other questions?
Yeah, Senator West, since you're the most senior of the senators here, I'll ask
Hey,
you.
hey,
this.
hey.
Can you, well, of those here, can you
Of those here.
can you remember this case and the school voucher issue on which the comptroller's office is, as I read it too, is acting outside the law and excluding some schools. Can you remember any comptroller doing this on this level?
No, not-
Acting outside the law to this degree on issues this big? And then the other question being maybe for you, sir, is whether the fact that he was sort of appointed in a circuitous way, does that factor into the legal arguments at all, or does that matter?
Well, let me say this, because I know Boris was right there with me. You want to answer that question, Boris?
My simple answer to that is, it does play a factor. He was appointed. And you know how this building works. You do something for me, and I'll do something for you. You know exactly how this works. But let me take the air out of the room since I've been called up. So. You know, this whole hub removal is baseless, it's biases, it's discriminatory, and it's catastrophe. And it's racist, plain and simple. Most accurate words to describe the systematic dissipation of the state's hub program. That's how we describe it. This program exists because history demanded it to exist. It was still necessary, and it's still necessary, so that minority-owned businesses can have a seat at the table. It's that simple. For decades, minority-owned businesses have been locked out of contracting process. Not because they were unqualified, because the system was rigged. Not because they were unqualified, because it was rigged. The legislature created the HUB program 35 years ago and tried to correct the injustices that were of the past. The removal of the minority-owned businesses by the controller is not reformable, it's erasable. That's what they're doing. And to hide behind veterans as justification, excluding minority-owned businesses, is a simple act of cowardice. It's that simple. The people of Texas deserve certain equity, fairness, and full protection of the statute designed to uphold them and the law. We will not stand by to allow this disenfranchisement or permit the HUB program to undo the official acting far from one official, to answer your question, far outside of his boundaries and his duties. It's called political theater.
Let me say this right now. Let me answer your specific question. I've never known another comptroller to do what Kelly Hancock is attempting to do right now. You asked about the voucher program. All of a sudden, there's nothing in there that, and we had a conversation in the education committee, I believe, about Muslims and all of
that piece of it.
Yeah, you're right. All of that was part of the debate. And frankly, no one was, even though I didn't vote for it, was left out. And then you have him coming out and say that those communities can't participate in the voucher program, or those schools can't participate, and then turn around and says that a voucher program is no longer valid, without any state constitutional authority to do it.
But Roy, it's not just a 35-year program design. The 35-year program is designed by the legislature.
Right.
Any other questions?
Well, you could answer the one I asked you, sorry. It was 10 minutes ago.
Rephrase it, rephrase it.
Rephrase the question.
The other one for you was Dalton, former Senator Hancock was appointed. Does that factor into your legal proceedings?
Well, the acting controller has not been elected by the people of the state of Texas. He is running for election, which I think, from our perspective, heightens the concern, right? The fact that even if he was elected, he wouldn't have the authority to do so, to do anything that he done. But the fact that he wasn't even elected by the people of the state of Texas actually makes this even worse. Any other questions?
Let's not let Texas be DC. And take our power away, our legislative power away. That's wrong.
I want to thank you all for joining us. I want to thank our courageous plaintiffs for stepping up to the table. And I want to thank the members of the legislature that are here with us, recognizing the importance of the legislature. They are here to pass laws, not executive branch members. And we anticipate this case will be heard before the judiciary, and we anticipate that we will prevail. Thank you all again for joining us.